Welcome to another episode of The Dissection. There's a ticking time bomb in the South African healthcare system. In fact, there are at least two, and billions of rands are at stake. Lives are at stake. What are those two time bombs? Number one is medico-legal costs, and number two is Section 33 of the NHI, which could lead down the road to the total dissolution of private medical aid. So let's start off with the issue of medico-legal, because this is a very big issue and something that came into the news last week and I think wasn't given as much attention as it deserves. So on Thursday, Parliament issued a statement, right? And this statement came from the Standing Committee on Appropriations. The chairperson of the Standing Committee of Appropriations, Mr. Musi Maimane, on behalf of the members of the committee, raised serious concerns about the escalating number of medical legal claims against the National Department of Health. The Office of the Auditor General of South Africa has said that medical legal claims are costing the healthcare sector an accumulative 77 billion rands, and the amount has over the years risen significantly rather than actually reduce, which was the target. The Office of the Auditor General of South Africa has said that by March of 2022, 148 medical legal claims had been lodged against the Department of Health, and these were actually valued at 125 billion rands. So if all of these claims are successful, 125 billion would have to be paid out. The committee heard that the provincial health facilities lacked reliable and accurate record keeping, and in most cases, this was caused by a shortage of administrative staff. Right? The claims arose due to expensive administrative costs, litigation processes due to medical negligence, and they've led to substantial compensation payouts for forensic investigations, legal fees, court settlements. And these claims obviously strain the department's resources and its ability to deliver quality healthcare services to South Africans. Some of the contributing factors, right? Some of the contributing factors are the following: poor management of patient safety, according to Parliament, incidents leading to patient complaints. Number two. Number three, poor management of medical records. Number four, inadequate health sector human resources. That's part of the story. There's another part of the story, and that's fraud. Fraud. And this is a big story that has been in Sunday Times this week, but not on page one, on page two. I think actually it should have been a page one story. Lawyers have milked billions from the state with fraudulent medical malpractice claims. The Health Minister, Aaron Motsoaledi, and the SIU have reported to the public about instances of fraudulent medical negligence claims, which amount to billions of rands by legal practitioners. The SIU revealed how dodgy lawyers have been basically looting state funds with bogus medical legal claims amounting to billions, and about 3 billion rands has been identified as being potentially looted by shady lawyers. Among the cases uncovered is one in which two different lawyers simultaneously claimed damages for the same case in two different courts. One case, the lawyers claimed 7.5 million. In another case, they claimed 25 million for the same case. Another case, 70 million rand claim was submitted for a botched circumcision at a hospital in Limpopo, but an investigation revealed that no such procedure was ever performed, but that the client actually had been treated for a serious genital infection, and that the hospital had actually, instead of botching his circumcision, actually saved his life. That's totally the opposite case. Totally. Another example, which was given in the Northern Cape, a lawyer won his client 18.7 million. This is a legitimate case. The case was won fairly. But instead of paying over the money, the lawyer was paying 6,000 rands a month to the person who won the case. And it would have taken over 200 years for the claimant to receive his full amount. Imagine that. What a dodgy lawyer, right? Because he's actually holding on to that money, using it. We've seen similar things with the road accident fund, where lawyers do dodgy things and hold on to money that they were supposed to give to other people. Some people would say, yeah, no, I want such and such amount, give it to me month by month so that I don't end up on I blew it. But 6,000 rands a month seems like there's something that happened there which wasn't appropriate, right? An investigation into possible fraudulent medical legal claims was launched in the Eastern Cape by the SIU, following a dramatic surge in malpractice claims in the province between 2010 and 2016. They rose from 46 to 529 in the Mthatha High Court alone. There's a law firm which has been mentioned by the SIU and the minister as having practiced some very dodgy stuff in relation to these claims. A Johannesburg-based firm, Nonquba Attorneys, is reported to have submitted 44 claims totaling 497 million against the Eastern Cape Department of Health in 5 years, leading up to 2017. And they are now actually facing fraudulent criminal charges. The firm is accused basically of targeting obstetricians and gynecologists involved in births where babies were born with cerebral palsy, a condition that can be caused by brain damage which resulting from a lack of oxygen. The SIU investigation found that lawyers or their agents were conning elderly people who were in charge of caring for their grandchildren as part of these schemes. The lawyers were posing as social workers from the South African Social Services Agency and telling victims that they were signing to receive child support grants when in fact they were signing over their power of attorneys, and then the lawyers would sue in their name, right? The SIU found that 15 letters of demand claiming 271 million were fraudulent. The people on behalf of whom they were written said they had never visited any of the health facilities that were being litigated against, and no records of such patients were found at the health facilities. So there's clearly something here which this firm was doing, which if true, is a little bit dodgy, is shady, and definitely fraud, right? If true. Mutsoledi said that 15 cases were what is it? So 15 letters of demand, the fake 15 letters of demand. He said that these 15 fake letters of demand were among 197 dating from the period from 2015 to 2021 that the SIU had identified for scrutiny. In that period, 2,500 claims valued at 22.3 billion were submitted to the Department of Health in the Eastern Cape. Right? There is a big discrepancy in how the different departments, for instance, the Western Cape Department of Health virtually has 0 claims of medical malpractice against it. But it's seemingly clear that Gauteng, Limpopo, KZN have had lots of claims against them. Right. Notably, these letters that were submitted by this one law firm. Were submitted by one law firm, which was not named because they've not yet been charged. Right. So what is being reported here is that there are multiple law firms which are doing this particular thing, right? The minister also said that there were instances of collusion involving officials in the office of the state attorney, whereby out-of-court settlements were being made for hefty amounts without actually the mandate or even the knowledge of the health department. In some instances in the Free State, nurses are accused of having stolen medical records, handed them over to attorneys, meaning that the court involved will rule in favor of the claimant as there was no longer evidence to dispute the case. Lawyers were also found to have withheld funds intended for the claimants. So there's a lot of stuff going on. In KwaZulu-Natal, the SIU probed 107 matters which were valued at 2.4 billion and found those matters to be fraudulent. 107 matters. Right? And 76 of the matters were actually matters where the claimants were actually deceased. One attorney was found to have submitted a claim valued at 16 million rands after the death of the child. Yet the lawyer was claiming for future medical care based on private hospital rates and loss of amenities of life. That's an example, another example. So it's very evident that the issue of fraud is a big problem in this particular costing of medical legal costs that are costing the Department of Health. It's very clear. These lawyers who are doing these things are taking advantage of people. They're taking advantage and exploiting, real issues that are arising within the healthcare system. So they must be held to account. Lawyers must be fit and proper. They must conduct themselves in an appropriate manner. The issue of fraud is a big problem. What is important, though, to note, and this is why it's a ticking time bomb beyond even the issue of the fraudulent lawyers, there were over 2,500 claims investigated in one province, right? And if you think about the total number of claims the article has referred, it's about 314 claims which they found to have flagged. 314 out of 2,500, right? If we just count just using that one province, it's 12.56% of the claims. Seems high, right? But we have to remember that the 2,500 claims are from one province. The Auditor General of South Africa said there were 15,148 claims that are lodged against the department. If you consider 314 out of 15,148, that represents 2.1% of all of the claims that have been issued. Meaning that the issue of fraud is a big problem. 2.1% of billions is not small money. It's a lot of money. As you can see, these amounts can, for the lawyers who claim them, 28 million, such and such million, that it's actually big for those law firms, and 28 million rands, 30 million rands, 7 million rands, these are large amounts of money. They can make a big difference, whatever the case may be. Someone who's sick, who needs, equipment, who needs particular treatment, they can actually get that treatment with that kind of money. So it's very important to point out that it's significant even if it's 2.1%. But 2.1% still leaves 97.9% of legitimate claims. 97.9% of legitimate claims. People have legitimate complaints against the Department of Health, and they have lost family members. They've been harmed in hospitals. These claims are not being awarded by courts just for fun. They are being awarded because judges are hearing stories of trauma, of malpractice that are so severe that they have to rule in favor of the plaintiffs. Let me give you an example. One of the most significant cases was a 2015 case, and it dates back to 2008. So by the time this mother gets justice, the case has been ongoing for 7 years, right? On the 3rd of February, 2008, a mother was admitted to Chris Hani Baragwanath for the birth of her unborn son, who was then unborn, right? She's pregnant. She goes to Chris Hani Baragwanath. And then while she's at Bara, the plaintiff endured several hours of labor pains, and that necessitated a cesarean section, C-section. She didn't get a C-section. Her son was born on the 3rd of February, 2008, by normal vaginal delivery. Right? So, after speaking to experts and all of that, the court determined that, as a result of the prolonged labor and the failure to timeously perform a cesarean section delivery, a C-section, this child was diagnosed as suffering from cerebral palsy. It's as a result of everything that happened at the hospital. The plaintiff sued the Department of Health in her personal capacity and in her representative capacity as mother and natural guardian of her minor child for damages arising out of the negligence of the staff at Baragwana Hospital and or Lenasia South Clinic at the time when she was admitted with her then unborn son. The court ruled that the defendant, the Gauteng Provincial Government, should pay the plaintiff a capital amount of 28.3 million rands. And this is how they broke up the costs. Number one, past hospital, medical, and related expenses, 222,000. Future loss of earnings, earning capacity, and loss of employability, 2.5 million. General damages for pain and suffering, loss of amenities of life, disability, and disfigurement, 1.2 million. Future hospital, medical, and related expenses, 24.4 million. And that led up to the cost of 28.3 million rands. And for some to say that, this kid who could have been a fully functioning member of society was only going to earn 2.25 million in his lifetime, maybe is an underestimate. And for some saying that, well, he doesn't have to go to a private hospital to get the medical and related expenses. He could go to a government hospital. Sometimes they don't have equipment for that. So courts have to use private hospital costs to make these estimates. So as you can see in this particular case, 28 million was awarded for something that could have been prevented by the hospitals, by various practitioners. And we have to acknowledge that as well, that there are many mothers, many people who go into hospitals expecting quality healthcare and don't get it. People lose relatives all the time. It happens all the time. And some of those people cannot even make claims because of the nature of the law of delict. So the lawyers should be held accountable. But this will not solve the other issues of medical malpractice and medical legal costs that have been identified. The 28 million payment, for example, was not due to fraud, but due to hospital overcrowding, lack of doctors available to perform the required surgery. The system is overwhelmed. And when that happens, there will be people who lose lives, and there will be malpractice, and there will be more mistakes. This is one of the ticking time bombs. But there's another ticking time bomb in respect to the healthcare system, and that is the issue of whether or not Section 33 will extinguish medical aid and what implications that will have, right? Because there's a discussion that's happening. And the Minister of Health, Aaron Motsoaledi, did an interview with Begisisa during the week and discussed some of the issues, especially around whether NHI will end medical aid, right? So one of the things that he said when he was discussing things with Begisisa, he said that, listen, one thing you need to realize is that what they're calling the GNU is not an alliance. That's what the minister said. And it's an opt-in, meaning that anyone who's opposed to the NHI, which is government policy, could always elect to leave. So he's saying that if the DA wants to go because of NHI, they can go. This is what he said. When we went into the government of national unity, we knew very well who we're going with. No one said that people who go into the GNU are alliance partners. We are not in alliance with the Democratic Alliance. We just went into a government of national unity with them because the situation demanded it. We know their policies are market-related and business-related. We knew there would be such contradictions. We will sit down with them and resolve them. If anybody believes that because of this misunderstanding, the government of national unity must collapse, then that will be very unfortunate. But what can we do? That will have been their choice. This is what he said. And when then the issue of medical aid came up, the issue of universal health care, the minister said that, he's willing to listen to anyone who has ideas or proposals for healthcare reform, right? Those who have said that, this is what he said, those who have said that they support universal healthcare, but not in the form of NHI. In what form do they want it? I want to listen. Maybe I can learn something that I never knew about. This is what he said. And when he was asked about Section 33, which is related to medical aids, right? What he said is that repealing the act or removing Section 33 is not part of the discussion he wants to have. I won't sit with anyone who does not want any reform of healthcare financing. This will be a complete waste of my time. That's what he said. So this issue of Section 33, Section 33 of the NHI Act explicitly and concertedly moves to remove medical aid in South Africa as they currently operate. The Act doesn't eliminate medical aids entirely, but it severely reduces their involvement in healthcare by stating that once the NHI is in effect, they cannot cover anything that the NHI covers. And then this reduces their role to top up funding for unknown extra services down the line. But this won't be immediate. According to the Act, only once the NHI is fully implemented will medical aids not be able to provide cover for services that are paid for by the NHI. As it stands, though, there's no indication as to when that fully implemented status comes into effect. Nor is there any indication of what services will be covered by the NHI. So until these issues are cleared up, no one knows how everything is going to play. However, Dr. Aaron Motsoaledi said that Section 33 is crucial to the NHI, and removing it would be akin to building a house without a foundation. It would simply collapse. This is the big issue that is another ticking time bomb in the healthcare sector. Because if the private medical aid system were to collapse, it's very foreseeable that there are people who will leave South Africa, medical practitioners, nurses, doctors, pharmacists, they'll leave to go to other places because, as you can see, there are some issues around payments, there's some issues around financing with the government systems in general. So people will say, no, I'm not going to take a chance that I'm not going to get paid, etc., etc. They'll probably go UK, EU, Canada, Australia. These are all places that can become available destinations for people to go to. The other one becomes elderly populations in South Africa. Affluent communities may also feel that they don't want to risk being stuck in South Africa without access to private healthcare. And, these things can be irrational. Fear is irrational. And you may actually start to see other professionals start to leave. So it's a ticking time bomb. It's a very delicate issue. Very delicate issue. And it could actually collapse the coalition as it stands now. Because the DA is supported by large numbers of white people in South Africa who use medical aid. I think there's about 9 million people on medical aid. They're supported by, large donors who have these companies whose, financial instruments are involved in one way or another within the medical aid. And it's very likely that they're not going to support anything to do with the advancement of the NHI. So if the NHI were to be pushed further by the ANC, the DA may walk. That could collapse the coalition that everyone has worked so carefully to build. So this issue is a ticking time bomb. And the issue of the NHI, medical legal costs in and of itself is another time bomb. A costly time bomb within the healthcare system. One of the biggest stories that I think we don't pay enough attention to. What do you think? Do you support the NHI? What do you think about the medical legal costs? Do you have people that you know who have been screwed over by the healthcare system? Have you lost relatives? Let's have a conversation. Let's have a conversation about this. It's a big issue. Till the next one.